Okay, video 8 or maybe 7, whatever it is. We just finished with talking about duties of the landowners. We're in chapter 6. Now we're going to talk about duty of professionals. So professionals in negligence cases have a higher duty of care than a layperson does. It only makes sense. You wouldn't hold a doctor who's performing surgery to a duty of care of a layperson. That would not be right. So we hold professionals generally to a duty of care of a reasonable professional of that type. And that's what we refer to oftentimes as professional malpractice. So it would be a reasonable lawyer, reasonable accountant, or reasonable doctor. In many cases in states like Georgia, you cannot bring a professional malpractice case against such a person unless you provide with your complaint, your initial start of the lawsuit, an affidavit from another professional who's knowledgeable in the area, who says that you did not conform your procedures to the ordinary care and skill of a professional of the same profession. So that makes it a little bit more difficult to bring a malpractice case. Okay, so if a surgeon operates on you and accidentally cuts an organ that they shouldn't have cut, you can't simply go to court and say the doctor made a mistake. You have to attach an affidavit from a doctor who's familiar with that type of surgery, who's an expert, who says that that violates the standard of care. That was not something that is to be expected as a normal course of such surgery. Georgia, about 10 years ago, passed a statute that raised the standard of care for emergency doctors. So doctors in emergency rooms do not have a reasonable emergency room doctor standard. Instead, you have to show in an emergency room that the doctor committed what's called gross negligence, which is a much higher standard. Okay, so Charlie Adams, who wrote the book in Georgia on torts, who's a tort attorney in Georgia, likes to say at his seminars, if you go to the emergency room and the emergency room doctor treats you and you're injured, you have to prove gross negligence. However, if the custodian coming through the emergency room leaves a slippery element on the floor and you slip on it, all you've got to do is prove that he breached a duty of reasonable care. So there's a higher standard on the emergency doctor than there is on the custodian or the janitor, which he would argue is ridiculous. There is one exception to this that the Supreme Court of Georgia has limited this doctrine to, and that is that based upon their reading of the statute, the Supreme Court of Georgia has said that the doctor in the emergency room has to be acting in an emergency capacity. In other words, what emergency room doctors do. So if you go in to the emergency room with something that's ordinarily not considered an emergency, which a lot of people do today. In other words, you've got a cold. Then the standard is one of the reasonable care of a like physician, not gross negligence. So it has to be something like you were in a car accident, you broke your leg in a sporting event, something that is a traditional emergency situation. Okay, so we talked about proximate cause. I'm not going to talk about that anymore. We talked about Palsgraf, and as I said, not everybody follows the majority opinion in Palsgraf. There's also a minority opinion which distinguishes between what's called the zone of danger. So in the majority, they said that as long as the plaintiff was in the zone of danger, then it's foreseeable. But if the plaintiff was outside of that zone, of where one could reasonably expect somebody to be injured, then there's no liability. The minority said it doesn't matter as long as somebody in the world was in the zone of danger. In other words, as long as it was foreseeable that someone somewhere would get injured, then you're liable. So most states follow the Palsgraf decision. Some states follow the minority decision in Palsgraf with regard to proximate cause. So I'm not going to talk anymore about proximate cause. Negligence damages are very much similar to intentional torts. You can get compensatory, special damages, and in rare instances can you get punitive damages, almost never in a negligence case. Now, other special statutes dealing with negligence include things like Good Samaritan statutes. This provides a defense to someone coming to the aid of someone who's in a emergency situation. Okay, so if you're driving your car down the road and a car in front of you runs off the road, turns over, and is upside down, and you go to pull somebody out of the car, and you save their life, and then they turn around and sue you because when you pulled them out of the car, you weren't careful and they got cut on a piece of glass from the window, you're not going to like that. And if you don't like it, then you may not go and try and save the person. So the law has created these Good Samaritan statutes that give immunity from being sued to somebody who goes to the rescue of another person. Another special area is dram shop laws, or dram shop acts, and these vary from state to state. Okay, they are laws that create an extra duty or a higher duty on people who provide alcohol to other people. So if you're a bar and you serve alcoholic drinks to people, most states have dram shop laws that say that you are liable for any injuries that person that you serve causes as a result of the alcohol that you gave them if you knew that they were reaching a state where the alcohol would impair their ability to conduct themselves in a reasonable manner. So typically, the bartender serves somebody too many drinks. The person says, well, I got to drive home now, I'll see you later, picks up their keys off the counter, goes out, gets in their car, and runs into somebody and injures them because of their intoxicated state. That would make the bar and the bartender liable. Some states limit it only to automobile situations. Some states make it very broad, and any tort that the person commits that was related to the alcohol would make them responsible. Georgia limits it to alcohol that is given to the person in a dram shop type of activity. Georgia does not carry it over to other situations. So be aware of that. Some states include parties. That's the reason that most businesses today, and this is an important part for businesses, if you're going to have a Christmas party, it's probably best not to serve alcohol because of these laws. If you're going to serve alcohol, make sure you limit it. So a lot of businesses today, my wife's former employer used to have a Christmas party, and they would give each person 2 tickets, allowing you to buy only 2 drinks, which was considered reasonable and not an amount that would intoxicate you to lose the ability to act reasonably. So be aware of these dram shop laws. Some states carry it over to parties, so these situations where parents allow teenagers to drink at a party could create some terrible liability on the part of those parents or adults. Okay, so we're going to stop there with, I guess that was 8, and we'll pick up with 9, dealing with defenses to negligence.